Hello, beautiful people, and welcome back. Conditional acceptance. When you hear many people speak of accept for value, they'll usually pair it up with the term conditional acceptance. In the past, over 2 separate videos, we went over the flaws within acceptance for value and what people actually intend to do and where the remedy actually lies within the Uniform Commercial Code itself. The buzzword, conditional acceptance. As we all know in commerce, everyone is deemed to be a merchant. And because you are deemed to be a merchant or presumed to be a merchant, you are presumed to be competent. And we also know that all laws are specific. And because all laws are specific, terminologies are very important. Terminologies are the mode of operation for any type of law, in this case, commercial law. Conditional acceptance, again, is a mere buzzword that serves no significance, especially if you don't know the actual operation or the reference within the commercial code. Most people who tell you, oh, they have no jurisdiction, they're functioning in admiralty. So conditionally accept it and return it, or accept for value and return it for settlement. They don't give you the reference to the Uniform Commercial Codes or break down why or how it ought to work, because they don't know. So ask yourself these basic questions. Where is the body of law that says I can conditionally accept this? And where's the foundational principle behind it? Here's the body of law, and then after this we'll go into the foundational principle behind it. It's in UCC 2-207, additional terms in acceptance or confirmation. This is the proper terminology that people misconstrue as acceptance for value or conditional acceptance. None of that exists. Even within affirmative defense in Rule 12 and Rule 8, it lets you know the closest thing to this is accord and satisfaction. It tells you a definite and seasonable expression, meaning it has to be clear and succinct, and when it's done, it is final and fixed. A definite and seasonable expression of acceptance, or a written confirmation which is sent within a reasonable time, due process. Most people don't do this within a reasonable time. Operates as an acceptance even though it states terms additional to or different from those offered or agreed upon. Most people do conditional acceptance in the sense that, okay, well, you're saying that I owe you this or that I'm guilty of this supposition of crime, since all crimes are commercial. Well, I'm willing to accept this upon proof of claim that so-and-so, so-and-so. All right. Nothing wrong with that. But do you know these details? And if challenged upon it, are you willing to whip out this body of commercial law as a backup to what you're saying? Legalese is a language of its own, and if you're not speaking their language and you're just using your own terminology and just throwing buzzwords out there, proof of claim, conditional acceptance, that has no standing. And that's why it doesn't work. You want to make it work? Here it is. A definite and seasonable expression of acceptance or a written confirmation which is sent within a reasonable time operates as an acceptance even though it states terms additional to or different from those offered or agreed upon. Unless acceptance, meaning whenever you modify that contract, you are bound by it, the initial offer. Because whenever you stipulate something else, it is presumed as though you have accepted it, you have confirmed it, and you have definitely expressed your consent to that initial offer, even if it's detrimental to you. Again, the loose term conditional acceptance, which is truthfully 2-207, additional terms of acceptance or confirmation. There are 2 main clauses to it. The first clause is whenever you add any terms and condition, it is under the condition that you've accepted the first offer, whether you're guilty or not. It's considered an acceptance whenever you modify it or add your own terms and condition. It's a confirmation. It's a definite seasonable expression of you accepting it if you're doing within a period of time. It's an acceptance. The second exception, or the second clause is an exception that says, unless acceptance is expressly made conditional on assent meaning contingent or encumbered or based on the additional or different terms. So they're telling you, if you don't bring up an expression within your terms and condition that, hey, I'm accepting this, but first this is a counteroffer. And once this counteroffer has been accepted, then the previous offer of yours now has standing or capacity. Meaning what I'm doing now is the primary factor. And what you're doing in that initial offer is predicated upon what I'm doing now. So you can either accept and add to what they're saying, meaning you can accept their liability or whatever it is that they're saying that benefits you. Or you can annul whatever it is they're saying, contingent upon what you're saying, which is where people try to do this whole conditional acceptance things. This is what they're trying to do. This is it right here. It's in 2-207. The only difference between this and accordant satisfaction is that accordant satisfaction is not really a modification of contract. That is another misconception. Accordant satisfaction is not a modification of contract. Because a modification of contract, the liability gets discharged immediately the moment it is modified. But the thing about accordant satisfaction is it first requires acceptance and process of it. So the discharge is not immediate or instant. So it's not a modification. So even then with this, it requires some performance and processing or acceptance of your counteroffer. In commerce, where merchant activities are involved or presumed to be involved, offer and acceptance based in condition, liability, value, aka consideration, compels performance. But in the middle of all that, there's a counteroffer, which is 2-207, additional terms, and acceptance or confirmation. Moving on, 2 tells you the additional terms, which we would presume here is that, hey, show me proof of claim that so-and-so exists. You don't have jurisdiction, right? Okay. The additional terms are to be construed as proposal. The additional terms are to be construed as proposal. Meaning we're not accepting it, but we can if we want to, but it's up to us. But the first in time, first in line concept in commerce still exists, meaning our claim precedes yours. So our claim remains superior. Our claim that you owe us this amount remains superior. Our claim that you're guilty of this remains superior. Because that condition that you have proposed based on 2-207 additional terms and acceptance or confirmation, that you're now saying we have to prove something or else it's modified or denied. Even though you're not saying you're denying it according to affirmative defense. You're not saying that. You're just saying, well, I will accept this if you show this and that. That is a mere proposal. It's a mere offer. It is a counter offer. Meaning in truth, it does not compel performance. That is the key to the whole condition acceptance thing. If you really want to say, hey, what you're doing is wrong and I'm not liable to this, you better start working the dynamics of the parliamentary rules. You better start looking to the Rule 8 and Rule 12 of the civil procedures. Oh, but don't worry, it's all their rules. Don't study their rules. Oh, but wait, UCC is also their rules also, so you might as well not study this. Oh yeah, you haven't. People who are telling you about conditional acceptance have either studied this, knows this, and are keeping this away from you, because this is where the true remedy is. Or someone has heard it and they are not studying this, which is the source of what they loosely use as that buzzword, conditional acceptance. And because they are not studying what they're saying, oh, it's their rules, it's their laws, they're suffering from it. That's why nobody can affirmatively tell you that conditional acceptance has worked or still works, because they don't know the dynamics of how it works, because they don't read the actual commercial law itself. But here it is being given to you. You are better than that. Be better. You're far more intelligent and far more capable than merely hearing somebody say something and then you just go ahead and do it without really knowing its source, why, or how, and the terms and condition behind it of how you can use it. Be competent. Be competent beyond buzzwords. Nonetheless, 2 goes on to say the additional terms are to be construed as proposal, meaning what you thinking is the end all meet all conditional acceptance. No, it's not. It's just a counteroffer. They don't have to accept it. The additional terms are to be construed as proposal for addition to the contract between merchants, meaning now you function in the contract law and you are construed to be a merchant, meaning you are competent and everything you say and do will be used against you. Such terms become part of the contract unless A, the offer expressly, meaning you write it down and you make it clear and succinct and unambiguously. It's not confusing, it's not in small print. The offer expressly limits acceptance to the terms of the offer. So this is where people say upon proof of claim that blah 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 that I'm guilty. They materially alter it, or notification of objection to them has already been given or is given within a reasonable time after notice of them is received. You know what this notification of objection is? It's the 19 types of objection that we've went over in the past. It is the Rule 8 and Rule 12 that we've also went over and over in many different videos. So you can do either one of these 3 things. 3. Conduct by both parties, which recognizes the existence, meaning this is not an unconscionable contract. An unconscionable contract is a unilateral contract. Unconscionable just means something that you would not do if you're in your right mind and you knew the full terms and condition. But the way most people attempt to use, quote, conditional acceptance is in fact in an unconscionable manner, whereby both parties do not recognize the existence. Because one, the one invoking it don't even know the proper reference to it to hold anyone liable to be able to enforce it if worse comes to worse. And 2, the other party knows that you don't know. Therefore, they just ignore it. They don't recognize it. The terms and condition behind what people loosely call conditional acceptance is that both parties have to recognize the existence of that modification of contract in order for it to be sufficient to establish a contract for sale. You're in commerce, right? You're a merchant, right? Although the writing of the parties do not otherwise establish a contract. Conduct by both parties, meaning your performance. All written agreements are still dead in the realm of artificiality. Performance is what brings it to life. Conduct by both parties which recognizes the existence, meaning performance of you modifying that contract and doing all those conditional acceptance of it, one way or another, which is listed here in section 2, A, B, or C. You have to do either one of these 3. Really 2, because A and B are the same, and then it says or C. So you can write all this down and do all these, but unless the other party accepts your counter offer and performs on it, remember both parties, you don't want this to be an unconscionable contract. Conduct by both parties which recognizes the existence of a contract, then once they've accepted it, it now becomes a contract. What people call conditional acceptance, which truly is 2-207 additional terms of acceptance or confirmation, first has to be accepted and then performed against in order for it to come to life, which most likely they will not do. And then the first in line presumption automatically takes place. So all that conditional acceptance has just effectively been a waste of time. But they're giving you a way out here, though. They're telling you have to object to it. If you're not doing your affirmative defense or invoking one of the 19 types of objections that we went over, what you call conditional acceptance is dead, and it cannot compel performance. Again, conduct by both parties which recognizes the existence of a contract is sufficient to establish a contract for sale. Although the writing of the parties do not otherwise establish a contract. In such a case, the term of the particular contract consists of those terms on which the writing of the parties agree, together with any supplementary terms incorporated under any other provisions of this article. What is the term contract for sale that it uses right here, where it says the contract is sufficient to establish a contract for sale? Man, it's telling you this is dealing with selling and buying something. So tell me, do you have an audit of that thing that they're claiming as a case against you, that you're guilty, or that amount that say you're owed? In order for you to do a conditional acceptance that you're saying you're doing, where's the proof of sale? See, mortgage companies snitch it themselves. They tell you it's been assigned. So sign something is just another cute word for saying we've sold a contract or an interest in a contract. And they usually get it for free. In that end, then yeah, sure, you have that evidence because they'll send you the letter. But what about a court case? Even if they open a new case number, where's the evidence of that old case being sold out? Do you have an audit on it? These are the subtleties that you need to put into consideration before you start doing what you call conditional acceptance. So what is contract for sale? In this article, unless the context otherwise requires, contract and agreement are limited to those relating to the present or future sale of goods. It's letting you know it has to do with the selling and buying of goods. Contract for sale, quote in bold, includes both a present sale of goods and the contract to sell goods at a future time. Future contracts. Literally, future contracts. It's a type of contract. So, it lets you know now that in addition to how you actually invoke what you call conditional acceptance, and the actual reference to what it actually truly is, this is regarding contract for sale. So what proof do you have that that case that you're doing a conditional acceptance for, what proof do you have that it's a contract for sale? Because you know they will deny this by all means. They will act dumb about it. So that's the foundation right there. If you can't prove that it's a contract for sale, you're tooting your own horns. Here's something that will make it a little bit easier for you. Now that we've known the true origin of what people loosely use as a buzzword, conditional acceptance, UCC 2-207 additional terms in acceptance or confirmation. Here are actually the proper term that applies in all court case, regardless of whether it's contract for sale related or not, which this is the specific verbiage you should be using. This is the dynamics here. But more specific to contract for sale, a type of contract within contract law. Instead of limiting yourself to what you call conditional acceptance, here's the true aspect of what actually is done. Oh, and by the way, before we go into those two specific terms, for those who are actually dealing in contracts and whatnot, as a side note, this might be useful for you. Look into 2-615 and 2-616. Okay, moving on. Here are the true terms that you actually need to use, not that buzzword conditional acceptance, which does not exist. true term, two of them is conditional precedent and conditional subsequent. What is conditional subsequent? In general, meaning general law, a condition is a term or requirement stated in a contract. Now we're dealing with contract law also. The last one that we've read, 2-207, deals with contract law, but in a very specific manner, dealing with contract for sale. This is letting you know right off the bat, generally speaking, it's not limited to any fixed remedy or any fixed type of contract, future contracts or not, present contract or contract for sale, whatever it is, it's not dealing with that specificity. It's telling you in general, then you can apply it all across the board, which is what people usually want to do. IRS sends you letters, student loan, court case, people are just using conditional acceptance upon proof of claim. No, that's not how you use it. Condition subsequent. In general, a condition is a term or requirement stated in a contract. This is what you're looking for. When it comes to contract law, you want to show competence that you know how to operate in commerce. You want to demonstrate that you know how to operate in contract and to create contract and to turn around theirs and subrogate theirs. This is it right here. Not conditional acceptance. It's called condition subsequent. In general, a condition is a term or requirement stated in a contract. Such a term can be drafted as a condition precedent or condition subsequent. So they're telling you your conditional acceptance. Why would you want to accept liability? And if you want to do that, it's based on limited concept of contract for sale. And there are two main criteria of how that can be enforced in that manner, which most people aren't doing. And most people cannot prove that the matter is dealing with the sale of some contract. Instead, what you need to do, see, people have that condition part, correct? But the acceptance part, they're admitting guilt. Why are you admitting guilt? When one, you don't know the reference and you don't know how it's being enforced. In truth, this is what you need, but letting you know in general. You want to create conditions, you want to modify it, cool, not a problem. What you need to do then is such a term, condition, can be drafted as a condition precedent or condition subsequent. This is contract law, among other things. A condition subsequent is an event or state of affairs that, if it occurs, will terminate one party's obligation to the other. Oh my God. They're telling you. Is that not what you want? When someone says you're guilty, when someone says you owe them something, is your intent not to actually terminate your supposed obligation to the other, rather than leaving it in the air for somebody to accept your counter offer, which is what conditional acceptance is. For your conditional acceptance to work, they have to accept your counter offer, because conditional acceptance is a counter offer. But this is letting you know condition subsequent is a condition that you can invoke that is contingent upon something that truly terminates one party's obligation to the other. For example, a contract might state something like, the client will pay for the haircut, meaning you owe me money if I cut your hair. Or that, well, I gave you this loan, so you owe me, now pay me. Unless the hairdresser does not perform the haircut. Well, unless I haven't given you this money, then you don't owe me. But what they usually come around and saying is, well, I have given you this money, so you owe me. I have cut your hair, so you got to give me the money. In this case, the client has a contractual duty to pay for the haircut. Why? Because I've given you something of value. And the consideration is my compensation for you to pay me for it. I've given you something of value, this loan. And the consideration is you got to give it back with interest. You're my debtor now. Or I have created a condition in the society that you shall not break this law. But you have. Now you're guilty and now you got to pay for it. Now show up to my court or else I'll issue a warrant and throw you in jail. That's what they're saying here. Now I'm giving you that analogy in real time that people go through to let you know what's going on. They're giving you an example with a client being given a haircut and being compensated. But in real time, these are the things that you're actually going along with, experiencing. Loans, mortgages, some type of supposition of a crime. And this obligation would only end if the hairdresser does not perform it. Performance. In other words, in order to prove that they are no longer bound, the client must prove that the haircut never occurred. This is what people are looking for when they're doing conditional acceptance. This is the doctrine and term that they're supposed to be invoking, not conditional acceptance, which does not exist. The closest thing to conditional acceptance is UCC 2-207. Additional terms in acceptance or confirmation. And then contingency is so much and so deep that one, it's a counteroffer that the other party who's making the initial offer first has to accept. And two, you have to do two of these things here, which most people, they only do it half-ass. And if they do it somehow one way or the other, which is the half, which is them expressing limits and accepting it under conditions, they don't know that it's limited to contract for sale conditions. And they usually don't have evidence that the whole situation is dealing with contract for sale unless there's an assignment letter written by the mortgage company. But in any other situation like court case, student loans, all that, they can't prove any of this. So it's confined to contract for sale, and there are limited obligations involved, and the conduct, aka the performance, requires agreement, aka they have to accept your counteroffer. But in truth, this is not even where your remedy is. Your remedy is in the true way to use conditions, which will terminate your obligation to the other man making the claim. This shows you no way to get out of any type of obligation or to terminate obligations. It just shows you, well, you can modify it, just wait for the other party to accept it, and everything is good and jolly, rainbows and unicorn. But this is letting you know, look, you can say screw all that crap that you have going on. This is what you want. It also lets you know, in other words, in order to prove that they are no longer bound. This is what everyone is going about when they say you have no jurisdiction. Conditional acceptance upon proof of claim that you have jurisdiction. This is it right here. In order to prove that they are no longer bound, the client must prove that the haircut never occurred, that the crime never occurred, that jurisdiction was never gained in the first place, whether it's subject matter, personal, or territorial, that the loan was never issued in the first place because banks have no asset beyond the asset of their customers to give out. All that stuff. This is the proper doctrine and condition and term that you ought to be using. Don't abandon it in place of some buzzword that doesn't even exist in the Uniform Commercial Code. And even if it does, it's vague and completely unrelated to how people are using it. So that's the first type of condition that you ought to use when it comes to modification of contract or holding people liable in order to remove performance or terminating a presumption of obligation. It's called condition subsequent. The second type of condition in contract law is called condition precedent. A condition precedent is a condition or an event that must occur before a right, claim, duty, or interest arises. Look at that. This is what people are looking for. Just invoke these proper terminologies because all law are specific. Legalese is a language of its own. If you don't speak it, they don't recognize it. And thus, you haven't invoked your right to anything in contract law. In a contract, a condition precedent is an event that must occur before the parties are obligated to perform. This is what you want to invoke. When you say somebody doesn't have jurisdiction or power over you, or that you don't owe them anything, or that proof of claim, condition acceptance, that's trash. What you are seeking is condition precedent and condition subsequent. And the subsequent aspect being it's already been expressed and stated within the contract, and now you're just enforcing it. Precedent meaning it has to first occur before it's written down or enforceable. A condition precedent is a condition or an event that must occur before a right, claim, or duty or interest arises. In a contract, a condition precedent is an event that must occur before the parties are obligated to perform. Did I enter into a contract with you? Okay, you're saying I do, but where's the conscionable aspect of it? Where's the validity of the contract? Whether it's in way of your standing or capacity, or mine for that matter, or the terms and conditions of the contract, or the subject matter of the contract itself. For example, an insurance contract, and this is just an example regarding insurance, it's not limited to insurance. For example, an insurance contract may require the insurer to pay to rebuild the customer's home if it is destroyed by a fire during the policy period, meaning that's the terms and condition of the contract itself. The fire is a condition precedent, meaning in order for the insuring company to actually compensate you out of that contract of insurance, the condition of fire has to occur. The fire must occur before the insurer is obligated to pay. Courts prefer to interpret a clause in the contract as a promise. Aren't we all saying all these contracts are promised to pay, there's no more money? Courts prefer to interpret a clause in a contract as a promise rather than a condition precedent. Precedent to avoid forfeiture. The second restatement of contract has dropped the term condition precedent and simply refers to it as condition. But now they've homogenized condition precedent and conditional subsequent as one. They don't even mention anything about conditional acceptance because it doesn't exist. And the closest thing that one can say exists is 2-207, which stipulation most people don't even align themselves with. And it's confined and limited to specific conditions in contract, to specific type of contract. But these two are generally speaking when it comes to contractual law. In property, a condition precedent is an event in which the vesting of a property interest occurs. If the condition does not occur before a specific time, the condition fails and the property interest does not vest. So, next time you hear someone tell you about conditional acceptance, think twice. Stop for a moment and look into condition precedent, condition subsequent, and then compare the principle of what they consider to be conditional acceptance to UCC 2-207, additional terms and acceptance or confirmation, and see if it applies. That is if they even explain what they mean by conditional acceptance, beyond saying, oh, they don't have jurisdiction. So tell them that unless they prove jurisdiction, then you're accepting guilt. Why would you even want to go into opening up the pathway and the possibility of you accepting liability? Even within the closest thing that appears or sound like conditional acceptance, they give you the stipulation that, look, you have to object. And that is one of the ways that you invoke 2-207. Or someone else is telling you conditional acceptance as well, I accept this upon proof of claim and so and so. No. Somebody has lied to the masses of people seeking to free themselves one way or the other. And so many people have been misinformed. Remember, information is not just merely to be accumulated or to just test and try and dig yourself into the deeper hole of that hole that Alice in Wonderland went into. Don't do that. You deserve better. Be competent. Competence is what compels performance. Competence is what compels just people to get away from you as fast as possible. And if you're doing what you think you're doing that's right and you're not fully competent and they leave now, they will come back in the future. They will come back because they know that you're not competent enough. And these people deal with hundreds of thousands of dollars and hundreds of thousands of people and papers every day. They just put yours to the side and come back to it later. They're not running away from you. especially if you don't put into consideration these basic things. Don't be busy using similitude of what could be. I'm sure someone actually knows these true aspects of how contract law works and right of claims, but they just give people the similitude that just sounds cute, and everyone has ran off with it. So, except for value has bit the dust, and so has conditional acceptance. Use the proper aspect of how it works. Only then would you begin to see functional change. So ask yourself, since condition subsequent is a condition in which an event or state of affairs that if it occurs will terminate one party's obligation to the other, and condition precedent is a condition or an event that must occur before a right of claim or duty or interest arises. Ask yourself, what body of instrument are they bound to in order for them to be able to first do what they do? And does their action align with their body of instrument? The solution is really that simple. It's just that simple. It really is. In math class, they give you all the issue, and then the teacher tells you, simplify. Meaning they give you all that complicated numbers and words, and your end goal is to simplify the answer. You get all this process of working this and that, and at the end you end up with a few numbers, but the process of it is all complex. That's what we all just went through, but the final solution is as simple as that. So the flaws have been provided, the dynamics of the flaw has been shown, the solution has been provided, the dynamics of the solution has been provided, and in just a few words, I hope you didn't miss it, in just a few words, the simplicity to the solution itself has been given to you. Best of luck.
Hey, and also don't forget to join my Patreon if you haven't. There I go through documents that I have used personally successfully and videos that I do not post here on YouTube that are in many ways private in nature. And also I go through live audio interactions and video interaction of my own experience with certain things. And I also have a website where you can go through a list of documents or services if you need them. And these videos that are posted on YouTube are also uploaded on Anchor. You can listen to it via audio means. And there's an Instagram page and a Facebook page. The link is on the screen and in the description. Take care and best of luck.